Professor, I'd like to draw your attention to the recent Supreme Court judgment with respect to accountability for the current economic crisis that led to bankruptcy, where accountability for misuse of power in decision making was directly attributed to identified individuals, including and not limited to the former president and former prime minister. Speak to us about the implications of this judgment. Help us understand better what we can do in view of this judgment.
Yes, Sonali, I think this judgment at this particular juncture is extremely important, not just from a jurisprudential point of view in a legal sense, but from the point of view of the people, because the action actually was brought by some particular individuals, and then also it was what you call a public interest petition, on the basis that it also was arguing that there was a violation of the rights of all the people of the country. So in our country we have this concept of locus standi to bring an action, and that was conformed with because of the concept of individuals going to court and this way. So the point of this case was to say the rights of the people had been completely disregarded, not in the policies or the legislation, because legislation in our country can't be challenged once it is passed. So the Inland Revenue Act had already been passed. So the question was, the challenge was to the decisions in public administration by the president, the executive arm, the president, the prime minister, and these people that actually contributed to the economic collapse. And they focused on the manner in which those decisions were made, the manner in which it was done, which did not conform to norms of good governance in executive policy making, which should be consultative, which would be based on information provided, etc. And they specifically use the words like unreasonable, irresponsible, not conforming to any analytical principles which should have been adopted, and irresponsibility in decision making. So we must not mistake it as an inroad of the courts on actual policies, which was the argument of in the dissenting. The dissenting judgment was based on the fact that this is a political question, this is legislation, because Parliament had already passed in tax law. It is also a political question which the courts should avoid. But the Supreme Court importantly said you can't use the cover of this issue of the separation of powers to clothe in legitimacy administrative decision making and executive decision making, which violates completely responsible decision making and policy. So arguments like this was in the mandate of President Gotabaya Rajapaksa. This vision of prosperity was in his manifesto, and this new homegrown solution to economic solution was part of a promise made to the nation. They rejected that attitude, and they said you can't do that, and then you can't then engage in all that and then end up in a situation where the country goes to bankruptcy, where you have failed to take into account even the actual advice given to you by the senior officials of the central bank. So you go off in your decision making on other imperatives. So accountable. And that is the concept of public trust. If you hold office, you should exercise those responsibilities in fulfillment of the responsibilities of office, which is to protect the rights of the people. That was one. The second premise was the understanding of equality. Equality in law sometimes is a narrow concept. In this judgment, they absorb the jurisprudence that the fundamental right is to equality and to equal protection of the law. Right. So consequently they said that you don't have to have a comparator even. The fact of the matter is, if the executive arm and the decision making completely disregards the rights of the people and the impact on the people, like for example this economic collapse, then the right to equality is also part of the rule of law and the violation of the rights of the people. So equality and equal protection of the law links to the very existence of the rule of law in the country, and they must conform to that. And failure to do that then is an issue of failed, they have failed in fulfilling the public trust. So, in that context, I was amazed at the manner in which this very important concept, which is the foundation of the Supreme Court decision, was tossed around in Parliament by the government, including, the way they reacted to the leader of the opposition's comment on the case by taking the file for him, throwing the file, grabbing the file from him, the chaos in Parliament, and the President himself making a facetious comment on public trust. When public trust is the responsibility of a person who holds office, not a person who comes into office, or not a person who refuses to take office. Public trust is the concept of your responsibilities in holding office. So, to trivialize it and use it as a general phrase that covers anything, it was sad to see that in Parliament. So, the judgment, I think, at this point is extremely important, because these imperatives on what is equality and equal protection of the law, how does it connect with rule of law and good governance, and how then does it connect to the concept of the responsibilities of office and the public trust, three important concepts which, if they are respected and become the foundation of governance, can then maybe give us a governance which we are not having.